take your seats. Hurry up. This is a slightly unusual seating we have here. We usually tend to congregate at the back, but now we have people trying to congregate on the left and the right. I hope it is not because of your political associations, but we'll be talking about the rule of law and international law. So you could sit both on the left and on the right of me, doesn't matter. Dear colleagues, good afternoon. Let me introduce myself. We have moderators of the section which is called Sovereignty as Supranationalism in Contemporary International Relations, and we have moderators Professor Alexei Moiseev, and he's the Vice President of the Customs Academy, and we have Anatoly Kapustin, President of the Russian Association of International Law, the Deputy Director of the Comparative Law Institute, Professor, Doctor of Law. We have the speakers of the panel present here. And there could be changes, and the changes, in fact, did happen. We have minor changes, but I don't want to introduce those changes now, but I will just introduce the panelists who will be taking the floor as we go. Let me make a very brief introduction. I don't want to reserve too much of the time allotted to our speakers. We have quite a few, and we also have a number of those present in the audience who want to participate in the discussion, so we need to be very brief and precise. And I do hope that this discussion will be very engaging. Now, why we're talking about sovereignty and supranationality, supranationalism? We have been talking about international law, but it is facing crisis. There were a lot said about that yesterday. We thought that in view of the risks to international law or support we want to give it, based on the two trends, some long-time trends, which has to do with the state sovereignty, states being the key agents and players in the international arena, and they are important both in the times of peaceful existence as in a time of crisis, and of course much can be said about supranationalism in these times. And we could refer back to history in the mid of the 19th century, when the very first supranational entities emerged, and much was said about the need for something that would be above the state sovereignty. And a number of organizations, international and regional, started to gain as far as supranationalism is concerned. Many new developments can be found, and we probably won't be able to respond to all of the questions and issues raised here. Some of the things that used to be clear yesterday seem to be less clear today. Basically, the issue that we are discussing here is very sophisticated from many angles. We have been hearing at this forum too that sovereignty is one of the key issues of international law, international relations. we need to give definitions to state players and their relations with international organizations, particularly in view of the integration trends, which may become almost obligatory. How could it be that states that enjoy sovereignty be part of that of these integration processes on the one hand? But both terms, sovereignty and supranationalism, have not been defined in any treaty. There is no universal definition of either of the terms. The only exception could be the Treaty of the Eurasian Economic Union. It says that there will be a supranational monetary institution that the organization will create with time. So we are here to discuss that, to exchange opinions and probably arrive at some commonality in our view of these two things. I don't want to allow for any discussion between the moderators, otherwise we won't have any time for the presentations. And the topic is in fact very sophisticated, very complex, both theoretically and practically. But I would like to start by giving the floor to Vice President of the Russian Association of International Law and Professor Tatiana Neshatova. Tatiana, let us agree on time. Can I give you just 10 minutes? But you can be allowed 15 because you're both a judge and an important professor and president. I apologize to the interpreters. I have 6 points I wanted to comment on. The issue is, in fact, complicated. Although practical developments show it's this complexity is due to the confusion. The institution which was supposed to be ruling the states, it dates back to the ancient times and to medieval times. In fact, this is nothing new in this topic, but it became practically important only after the Second World War, and I think it started being implemented in the Bretton Woods agreements and their 4 pillars of the International Monetary Fund, which was actually developed by some Russian and European academics. However, the Europeans could be said they were prompted by some of the Russian scholars. I don't want to get into this discussion here. We had this intergovernmental institution which started growing and putting the states under control. However, it has only indirect relation to the subject of sovereignty, because an intergovernmental institution which were conceived as intergovernmental were only that. They never became supranational. The supranational institution should have 2 issues: intergovernmental and be a supranational. If you take our union, we are supposed to pursue coordinated policy, and it is only when the states voluntarily delegate some of their competences to some common bodies, and this competence is limited by this delegation. This dream of supranational institution has never been implemented. It was never achieved by the Europeans. If you take, for example, the way the bodies are structured, and we have 2 two of them that following classical intergovernmental mechanism by agreeing all decisions through the consensus. We have two of such bodies. We have the Supreme Council and Intergovernmental Council, and they are allowed only to coordinate strategies because it's almost impossible to rely on consensus to achieve anything. It is very difficult. So we have these two bodies which were set up specifically to fall back on very good experts on integration. They pledge they will not be limited by their national affiliation, but will be doing things only for common goods. So it is the only way it can work. So we have two such bodies, and they are supranational. Some forgets that we have two such bodies. One is this Integration Economic Commission, which is basically the courts, and we have many judges of this court present here. Now, why? I don't think it has anything to do with sovereignty. I think Lenin actually has the best authority on sovereignty because he did a lot to describe the sovereignty. According to Lenin, sovereignty belongs to the people, and people delegate its sovereign rights to the government, to the bureaucratic structures, and those structures control the relevant territories and sovereign vis-à-vis other international players. This bureaucratic government, which is based on the will of the people, may delegate their authority, some of them, to another institution which is supranational. Of course, it is all down to this issue of balance. What sort of authorities should be delegated and which should not. So I would think that Europeans may went too far. And it looks that members of the European Union do not have the right to apply international law in their name. So they delegated their rights to the European Union. And it's all down to the national government, what scope of authority they want to delegate, and it's down to the practical approach. I'm hoping that our union will act slightly better. Now, could we say that the recently created institution is supranational? It's got four major properties. It will be directly controlling and governing individuals and corporates. The bureaucrats will take the pledge to divest themselves of their nationality. All the decisions are compulsory and binding, and there is the enforcement mechanism. We have a very original enforcement mechanism. In the European Union, it's all down to money. You pay if you don't comply. And in our union, the case goes to the Supreme Council. We'll see which way is better, whether the money speaks better or whether the presidents and the courts could be better to ensure compliance. I think that probably in our case the latter is true, but it's something original. Now, as for integration, it could be both intergovernmental and supranational. But one thing is obvious, where they failed to combine these two methods, there's no proper integration. I'm quite confident of that. It didn't happen in the CIS, it didn't happen in the European free economic zone, and this is our third attempt, and I'm not sure that it will succeed. But we live in an interesting time, and we could try to do our best, and then we could hope for very good prospects, because you can't survive all on your own. Integration and supranationalism is a choice of pragmatically minded people. It's the only way to survive. Now let me talk about dangers or risks. And about issues that I see in our treaty. The treaty is not that bad. It was created based on an interesting approach. It was drafted by academics, and then it was transferred to bureaucrats, and bureaucrats did their job there. But then it went to the national governments that didn't want to cede too much of their powers, so the final result is quite original, quite unique, but we have some risks. The first risk is when the national governments try to interfere in the treaty drafting. They tried to cut back the supranational bodies. In particular, they were disallowed to present their actions in courts. In Luxembourg, the European Commission has this right. Our Commission doesn't have it, and we need to make sure it has it. The government that doesn't have this right is not the government. I think the reason was the greediness of the local bureaucrats who kept harping on sovereignty. It has nothing to do with sovereignty. Then, of course, it's also to the detriment of the courts, of the judiciary, because the court needs to rely on uniform practice, and it is important. The Intergovernmental Council, the Supreme Council are consensus-based. Good rule and law cannot be achieved, cannot be arrived at through consensus. It will be having gaps. It will be far from perfect. It's only courts through interpretation that could make any rule better or perfect. The integration in the European Union legally was created by the Luxembourg-based court through the traditional way, by construction, by interpretation. It is has been down to the judiciary customs, and you know the law has come from the judiciary customs. And so now the next step is down to the Commission, whether they accept what the court has pronounced or improve on it. And this is the way it actually worked. Some of our constructions have been included in the binding rules. I apologize, your time is up. So we are hopeful about a treaty. But what is important is that the courts can get its possibility to interact with the national governments as well as with the Commission, because the national government has no longer the right to go directly to our courts. But I don't think it's right, because you don't get uniformity unless you get uniform.
Thank you, Tatiana. I believe your optimism is quite justified, and international law is familiar with the existing practice. The practice cannot change the treaties, but it can make sure that the treaties get adjusted. So hopefully the practice goes in the right direction, in the direction of achieving the goals of Eurasian integration and strengthening rule of law. Let me introduce now and let us welcome somebody who is very important, who is Under Secretary General for Legal Affairs and United Nations Legal Council, Miguel de Serpasares. Russian is channel 4, English is channel 5.
Thank you very much. Good morning, everybody. Unfortunately, I cannot communicate in Russia. I apologize for that, but we have good interpreters, so I will be able to participate in this discussion with you and to share some ideas. And thank you for your introduction. I'm not a very important person. I'm a humble international civil servant at the service of member states, because the United Nations is mostly at the service of member states. And I really think you have put up interesting topics for discussion. Nowadays, I think it's not possible to discuss sovereignty without also discussing supranationalism. So the coupling of these two discussions is very fortunate and very good. Maybe we should start, and I follow your suggestion, to see if we can reach a common definition of sovereignty, because if we want to engage in a debate, an open debate about these two topics, maybe we should start by making sure that we have the same notion of what sovereignty and what supranationalism is. I will attempt, although I'm not an academic, I will attempt to give you some ideas. I realize that sovereignty is often used as an adjective and very rarely used as a substantive. If you read the Charter of the United Nations, for instance, I think you have 33 references to the term of sovereignty, but always used as an adjective, never as a definition. So we need to try to put some content in this notion. Now, if we look backwards, I don't think the notion of sovereignty has changed much since the 18th century, for instance, or even before. I think we could define it internally as a power to exercise jurisdiction within a certain territory and upon certain citizens. And also on the international sphere, I would define sovereignty as independence. I found a very good definition, an old one from an arbitrator in the Permanent Court of Justice, Max Huber, who said in 1928 in one judgment, one decision, that sovereignty in the international sphere just means independence. Independence in the sense that the sovereign state extracts his powers directly from the international order and does not have to submit to any other entity. And this is, although we are in an evolution, many things have happened in the last, let's say, 70 years. I say 70 years because this is the year of the 70th anniversary of the United Nations. It's an important year. And we will discuss in the second part the supranationalism, integration, but it's still the basis of the international legal order, this notion of sovereignty. If we go to the Charter, one of the basic principles is the sovereign equality of member states, and there is a very good definition of this coming from the 18th century, from Vattel, who said that a dwarf is as man as a giant. A little republic is as much of a state as a very strong and powerful kingdom. Now, this is nowadays the basis of the international legal order, sovereign equality, and then we have to take up this discussion and think what is the meaning of the supranationalist trend, and how does it affect this notion of sovereignty as power and independence. And then, of course, we would have to look more closely into integration projects. I'm very familiar, it was referred by my predecessor, the distinguished judge, the European Union. I actually have spent 9 years in the European Union, so I'm quite familiar with the process of European integration and how does it affect states. Just to begin with, it was also referred this notion of transfer of sovereignty. The way I see it, for instance, in the European Union, I do not see a transfer of sovereignty. I see rather a common exercise of sovereignty based on consent. The sovereignty is not transferred as such. It's exercised in common in the different institutions by member states who have voluntarily agreed to this exercise or to this common exercise of sovereignty. Now, I think another interesting topic for discussion would be among us to recognize if there are limits to this sovereignty, and this means more specifically, can we operate under a concept of absolute sovereignty? Over the past 70 years, are there limitations for this sovereignty? Do we have to operate more under a concept of relative sovereignty? What does that mean exactly? Are those limitations imposed by international law, or are those limitations imposed by the reality of the modern world? Because one of the topics I think we should not forget and we should keep in mind is that a lot of the problems that modern states have to deal with nowadays are very difficult to address alone. So all these multilateral processes, all these integration processes, are also ways that national states have designed in order to help them deal with important problems. Think of migration, organized crime, climate change, infectious diseases, even economic globalization. There are so many new phenomena that member states of international organizations have to deal with that I think, especially after a Second World War, even if the European Union, for instance, started as a political project and not as much as an economic project, I think that states have realized that it would be very difficult for them to tackle with all important problems alone and outside a cooperation or integration project. So I think this is a very good basis for discussion. I also hope that the audience will share some ideas with us to make it more dynamic, and I'm looking forward for our discussion today. Thank you.
Thank you so very much. Thank you so very much. Yes, the experience of the European Union is essential for our integration association because we always pay a lot of attention to the results achieved by European states. And the experience of the Soviet Union in the best meaning of this word must be taken into account as well. Integration, or the Soviet Union may be perceived as an in-depth integration of states. That may be a subject for a whole different roundtable discussion, but nevertheless, what we have now, the integration we have now with our neighbors, the Eurasian Economic Union, and the issues we are discussing at this roundtable will have to be tackled together. And now it is with pleasure that I give the floor to the Deputy Minister of Justice of Belarus, Mr. Tushinsky. He represents one of the states with which we keep discussing the issues. Thank you. Dear colleagues, a lot has been said about the experience of European and Eurasian integration, about European and Eurasian integration projects. European and Eurasian integration had different starting points. Their goals were also different. That's why when Eurasian integration, Eurasian economic integration was developed, the European experience was taken into account, analyzed, but not copied. Eurasian integration, if you look at it, the best product of it is the Eurasian Economic Union, because the free trade zone was only created as part of Eurozec. And in CIS, we have a very recent agreement to that effect with a lot of exceptions and exclusions. When we were creating the Union, when we were beginning to tackle the issue of Eurasian integration, the first thing to decide was how we want to divide our competencies. That's a fundamental issue every time you create something supranational. Like I said, we decided against copying the experience of EU, even though there were proposals to do so. The reason was that the presidents decided against having a common parliament. And another reason was that the principle of subsidiarity is highly debatable. Let me give you an example. Under the subsidiarity principle, a union in the areas which do not fall under its sole jurisdiction only acts if the member states cannot achieve agreement on the national or regional level and may be better achieved on the union level. Let us simplify this very cumbersome definition and use a better language to say the same. If there is an issue which is not under the union's jurisdiction, but it is necessary, then the union may make a decision without having special jurisdiction. So it's a political compromise. It's not a legal principle. All of us know very well when it was included, but we cannot and could not use it as a foundation for Eurasian integration. I'm not saying that we had to write theses and doctorates about that. The Belarusian delegation had our proposals, which we submitted to our Russian and Kazakh counterparts, and then we described in a lot of detail areas which fall under exclusive jurisdiction of the Union, common jurisdiction and national jurisdiction areas. And I think this whole business of dividing jurisdictions and competency is necessary to decide one thing: who can make what decisions and in what format. We went further. We proposed to include another element, a political element, and a policy rather. There is joint jurisdiction, there is union jurisdiction, national jurisdiction. But our partners did not quite understand what joint jurisdiction meant. Is it joint jurisdiction of the member states? And that issue was raised during negotiations. Or is it a joint jurisdiction of 3+1, member states plus the union? Even though we did not achieve common understanding, it has to be done. When we decided against the European experience, we did not create anything to replace it. That is too bad. because it removes the limitations or limits which can prevent us from making frivolous decisions. We need clear limits, clear borders telling us when it is a supranational body who makes a decision and when it is several member states who make a decision as part of joint competition. Our commission consists of two different chambers. The collegium is a purely supranational body. They make decisions by simple majority, but the council has more intergovernmental functions. The decisions are made there by the existing high-positioned officials of individual member states. So the jurisdiction made it possible to make decision as part of the union's sole or exceptional competition and as part of joint composition. We also had a proposal about auxiliary bodies because you theoretically may have borderline issues which theoretically may fall under one or the other jurisdiction, because life is life and you cannot always draw a clear borderline. But most importantly, like I said, to divide jurisdiction and have a very clear understanding who develops which policy and who makes which decision. We don't have it currently. And as a person who spent a lot of years to develop Eurasian integration, it's a weakness. It's a weakness which should be taken care of in the very near future. Without a clear distinction, without a clear definition, the union will not be able to develop successfully as an economic union as opposed as just a customs union plus something combined in a single document. Will help you. Thank you. Thank you very much. Thank you, Igor. And now I would like to give the floor to a representative of a different member state, Deputy Minister of Justice of the Republic of Armenia, Mr. Kachiryan. Thank you very much. This discussion today is very, very interesting because we are trying to compare some theoretical provisions to the processes which are in place in the Eurasian economic space. And here you may exercise several different approaches, use different approaches to the process we are dealing with. Initially, there may be two different methods to be used to build integration. My colleague said one is to draft clear definitions and very clearly define the powers, how they are divided nationally, internationally, and supranationally. And here there are very favorable conditions to do so now, and there is a good experience of supranational bodies. We are very well familiar with the European Union, with its advantages and disadvantages, and that is a good way to follow for us. Like I said, this experience will continue to be taken into account.
It's also important to understand that balance is needed, but it takes time, a lot of efforts, and every act that leads to decisions, either at the union level or at the intergovernmental level or the national level, each such act would be in response to some specific issue in the context of the compromise, and this process is underway, and relevant decisions would be based on the conditions and developments as far as the integration is concerned. It might happen eventually that some academic theoretical constructions will be going against more practical solutions. The same is true of other parties to the process. We've just heard about the contribution of the judiciary. Well, you should appreciate this is all very fluent. It's all under development, and it's the same was true of the European Union and European bodies. They didn't come about having the kind of powers and authorities they have now. What is important is to take into account the circumstances on the ground. We need to look for the best solutions that would be in line with what we have in Eurasia. Thank you very much. Thank you again. We have here some international bureaucrats in the good sense of that word. When I became moderator, I felt there's something wrong because we have here more people from the Eurasian Commission. We pin our hope on what they can do to improve the integration. We have Deputy Director of the International Department, Lydia Trkhanovic. You have the floor. My professor of international law, Anatoly Yakovlevich, always said that the rule of government was always supreme. When the government decides to integrate, it would either stay some of its sovereignty or probably give up on some of it for a certain period of time. When I started working at the Eurasian Commission, we are bureaucrats, but we don't have any designs to increase the functions available to us. I may be romantic as far as integration is concerned, but we should appreciate that some of the issues can only be decided through integration. So we need to think of whether some acts can be approved by the national government, and if they can, they will do that. If not, then it's the competence of the Eurasian Commission. The Eurasian Economic Commission has a certain set of functions, and we have this clear-cut competence, clear-cut jurisdiction. But sometimes these competences, this jurisdiction is not defined. And if we can't divide jurisdiction in a classical way, of course makes our job very difficult, because government tends to remind us about their sovereignty directly or indirectly, and they keep saying that you have been usurping our powers, that you have been regulating what you couldn't be regulating. But in fact, the government has a lot of powers to protect and defend their sovereignty. We have a lot of projects that have to do with our interaction with national administrations. It's important for us to interact so that they would be relieved of their concern about the sovereignty, and so that we could understand what sort of national interests they have. Of course, we as bureaucrats cannot properly feel for the national sovereignty. It is very important for us to get the feedback from the national governments and to know whether we have stepped over the line. My personal opinion is that sometimes member governments tend to forget that that the Eurasian bureaucrats are independent. We don't have to take the pledge as judges, but we are aware of the fact that we need to be we need to strive to be independent. After 6 o'clock in the afternoon, I can remember that I'm a citizen of the Russian government, of the Russian Federation. It's not something I will be thinking of during the working hours. But of course, I'm aware of the national legislation. But of course, we cannot get instructions directly from the national administrations. The procedure for decision making is not based on consensus. We do listen, we do interpret, we may accept, we may not accept, but it's not the consensus based process. Another instrument available to the national government is the institution, or rather the Institute of repeal. It can be used before the decision has taken force, has taken effect, and then national administrations could claim that we have stepped over the line. In some issues that we dispute or we discuss involves vice premiers, and they judge about the decisions taken by the boards of the commission. And at the next step, the boards may fail to reach its consensus, and if if one of the national governments may be arguing against some tariff, other governments may argue in favor of it, and unless this decision has been signed into life, they can continue interacting. So the difference between the European Union and Eurasian Union is that the decisions taken by the European Union can be signed by the chairman. We have to have 5 signatures, 5 vice premiers. So you could appreciate it's quite a difficult case to obtain this decision, to confirm the decision if one vice premier is against. The same kind of a procedure is in force for the Supreme Council. So it's not just a consensus, it's something more. We don't have a chairman in either of the bodies. We seem to have instituted the position of the chairman, but they don't have overriding powers. As a result, the procedures may be time-consuming, and some of the governments may delay signing indefinitely. If I go back to this institution of repeal, it is if the government believes at the stage of the Commission that the decision of the Eurasian Commission should be discussed at the Supreme Commission, it will be done so. We could revoke some of our proposals if any of the governments may be against them. Sometimes our boards may decide to accept some of the suggestions of the national government. So now we have this institution of revoking our decisions. We have been deprived of quite a lot of functions at the Commission. So we've been fighting for our jurisdiction, and we've been losing in the most important areas. Some of them could be quite important. For example, we can't go to court anymore, which is quite strange to me because we could be quite instrumental. But we're very grateful to our courts because through construction we were prompted that even if we can't go to court directly, we could ask courts to do some interpretation and construction. And through that construction, we could get some sort of a ruling, a resolution by courts that will be binding for the national governments. For our members, I could say that their sovereignty has not been undermined. We have this feeling wherever we feel that the sovereignty may be endangered. We always look back to what the European Union is doing and how they've been acting for the right of the European Commission to negotiate international treaties. It's an important function. It's an important power. If we are not given it, we see integration being undermined. Another instrument is the so-called advisory bodies. They work very well because during their sessions, members transmit their worries, their concerns to us directly. Those secondary or advisory bodies are important, and we try to do that for the purposes of the so-called advanced cooperation. The very first institutions will be set up for the sanitary and veterinary controls at the level of the directors of the relevant services. We'll be also introducing the so-called working groups and conferences. They are the fora that can deal with this balance of sovereignty versus supranationality, whether the Commission is acting within its jurisdiction or has overstepped the line. The term sovereignty is used 5 times in the main treaty and has to do with the important sectoral areas like monetary policies, borders, and the declaration of the Eurasian integration says that the union is based on the sovereign integration. Now we talk about sovereign equality. It's a slight modification. Let me give you an example of how the parties managed to advance and promote their sovereignty at the supranational level. We were working on our uniform procedures for tariff setting. One of the governments insisted that the method itself should say that it cannot undermine the sovereignty of the government. Thank you very much. Thank you, Lily. I would like to give the floor, and I don't want to comment at this point in time. We'll have time for a discussion. But as life suggests, when we move from theory to practice, this practice creates and prompts a lot of questions, and we need to discuss them for the integration to go forward. I would like to give the floor to the key advisor of the Constitutional Court, Vladimir Golomyan. Thank you very much. I don't think it will be wrong if we try to look for the reasons of confusion, whenever we compare the words integration, sovereignty, and supranationality. Immanuel Kant used to warn against a formal logic which may lead the human mind in the wrong direction. So if we are to be guided by these definitions without thinking about the proper underlying substance, we could hardly get good decisions. Good decisions can be reached through good thinking. And I would like to join and support the position of Miguel de Serpa Soares. My intention was to talk about the state sovereignty of Russia and its integration as part of the bigger Europe from Lisbon to Vladivostok, as part of this concept of integration under the auspices of the Council of Europe. Now, if you take these two terms from the point of view of the sovereignty of the Russian Federation, the Constitution says that the Russian Federation is a democratic state based on the rule of law. So we'll be talking about sovereignty of a democratic government ruled by the rule of law. We was saying times and again that the state sovereignty is the full sovereignty inside the country for its executive, judiciary branches, and on the international arena, this is the sovereignty of interaction. The Constitutional Court allowed for the integration based on the Constitution, which talked about the need to integrate its Article 4 and Article 79 of the Constitution. The first article has to do with the priority of international treaties, and the other one has to do with the possibility for the Russian Federation to delegate some of its powers to international associations to the extent where it doesn't run counter to the human rights and the basis of its constitutional order. And the constitutional order is based on democracy, rule of law, separation of powers. So if we compare this understanding of the sovereignty of the Russian Federation with the integration with the bigger Europe or the greater Europe, we need to consult the charters of the Charter of the Council of Europe, its treaties and other treaties over 200, the practice of the Human Rights Court, and we see now, given that, that this integration is an association of democratic governments based on the rule of law and human rights. What does it mean? It means that this association is based on the dignity of the human being, the dignity of the individual, based on freedom, solidarity, and equality. These basic values underpin human rights, its moral rights, the humans' moral rights, which are values that are permanent, which do not depend on prejudices or some short-term interests. These are permanent values based on the reason, on the wish to exist in harmony, to interact in harmony with other people, with other communities, based on the principle of equality, which also is a part of our human mentality, which is part of our being, which we need to interact with other states and individuals.
And of course, this kind of understanding or perception of integration It's in the context of the Russian Federation, which is a rule of law democratic state, makes it possible to say that these two concepts do not contradict each other. They cannot be used as juxtaposing each other, because every juxtaposition in this context would be wrong, would be a mistake. And it is never clear whether such a mistake is a bona fide mistake, mistake made in good faith, mistake caused by formal logic imperfections, or is it a mistake which is quite intentional? A mistake which is made due to lack of willingness to respect the Constitution. But whatever it is, it's a mistake. So from the point of view of integration in bigger Europe, there are no dangers for national sovereignty. It's not an issue. What can our critics say to disagree with that? They can say that integration into bigger Europe is quite an intensive process per se. Integration gets stronger with time, and it is quite clear why. Because from the outset, integration is aspiration for unification, for better human rights standards. That's why any nation based on the Constitution, and the Constitution proclaims the same thing, ongoing enhancement of human rights standards, ongoing improvement of quality governance, of respect of human rights. So all those instruments make us exist in the same integration trend, pro-integration trend, if you will. So all such arguments do not work, may not work. One may argue that the European Court for Human Rights shows that European consensus, or European consent, comes to the forefront. It keeps changing. We keep dragging behind those changes, but those changes nevertheless impose certain commitments on us. Here you may say that all such issues, if they arise, are always very specific, and the European Court focuses most heavily on their rights, and as such it is guided by a reasonable approach. It is never guided by the interests of today. And the countries which participate in the process can always, using adversarial methods, stand up for their rights. It's precisely what Ireland did in ABC against Ireland, which was a high-profile abortion case. So even in an issue with all European consensus, a state may try to prove why and how they want to be different, but they have to do that. In conclusion of my presentation, I would like to reiterate once again that the context which I used to describe those two concepts make them non-controversial. Thank you. Thank you, Vladimir. You prove the idea that the issue of sovereignty is not limited to sovereignty. It includes a whole range of issues, and they all are interrelated. Thank you. We have another representative of Belarus, Deputy Head of the National Center for Legislation and Legal Studies, Tatiana Mikhailova. Tatiana, you have the floor. Good afternoon, dear colleagues. It's a great honor to speak in front of such an excellent forum. I'd like to participate in the discussion, but I have a paper, but because so many interesting things have been said, I'd like to go back to the start and speak about the relations between sovereignty and subnationalism. The concept of sovereignty is something that we have known forever as a special category. But this category is an integral part of a state due to the nature of a state. That's why it is, like I said, inseparable, integral part of the definition of a state. And in that context, yes, there is no conflict between sovereignty and supranationalism. Supranationalism is a new thing compared to sovereignty, which is several hundred years old. It's 50 years old at best. Why do they not conflict with each other? The lawyers very often show the difference between the same concept in statics and in dynamics. The same goes for sovereignty. Static sovereignty is an integral feature of a state. It can't be separated from the definition of a state. And in this context, to speak about delegation of sovereignty to somebody else is unthinkable. In dynamics, it's a procedure of the exercise of power, exercise of authority, and in that context, we may speak about redistribution of powers. And then supranationalism is nothing but a function. It's a function-based concept. And it is not by chance, like my colleague from the EU Commission said, it is not for nothing that the concept of definition is not used so much, because it's not the place for sovereignty. It's a clear mechanism of redistribution of powers, delegation of powers on a different level, and the common use by the governments, by the nations, of a different legal mechanism. It's like a government or a nation may decide to use some provisions of foreign law, international law. This reference to the jurisdiction of an international organization does not pose a threat for sovereignty, because nationalism or supranationalism is nothing but a function. You have to be very clear about whether it is a target-based, target-specific jurisdiction or statutory jurisdiction, and then we must define jurisdiction in a treaty. And today, if you look at the Treaty on Eurasian Economic Unity, the jurisdiction is clearly defined. Look at the treaties governing European integration. They have certain provisions which may be used as a way to circumvent the fundamental principles. Well, supranationalism may be different depending on the context. It may be supranationalism of a body or an organization. It may be total supranationalism or partial supranationalism. There may even be supranationalism of a separate provision. Why are there so many different forms of supranationalism? It may seems weird, I agree, but for international cooperation, especially integration cooperation, what is sometimes used is supranational method of regulation or supranationalism method. We are familiar with that from the European experience. There it is known as a Monnet method. But what Europeans wanted to put into the supranationalism regulation method did not always work, and the expectations were sometimes deceived. Well, the first community, you remember, was created in the area of coal and steel, the area with the worst conflicts after World War II, or they were created in very specific areas like the area of trade or uniform regulation of customs, tariffs, etc. And Eurasian integration follows the same path, so to say. So what Europe tried to do with respect to supranational regulation method did not always work, like I said. If you speak about the political context, it did not work at all. From the very beginning, they tried to create a European political community, defense community, but it didn't work. Nothing came out of it. And so as for this most sensitive issue, supranational regulation in the political area, which is very closely related to this sovereignty issue, because the foreign policy is directly related to sovereignty. That is what they came to very recently. Only now they're discussing the issue of common foreign policy, and that issue remains to be highly debatable. Even though it is being discussed, that has to be recognized, and how common foreign policy mechanisms are effective is a big question mark. The only area where they have been successful is common trade. So the European Union designed a new method, a method of intergovernmental or international integration. That is the name they use. What is the purpose of this method? They say it is okay. They say it's appropriate. It is appropriate not just separate between those two concepts, but to use them in a balanced way. So what we have on the supranational level is only what cannot be regulated on the national level. Another thing to emphasize now, ladies and gentlemen, it has to do with the balance of interests I previously mentioned. It goes without saying that no matter what international organization you deal with, and no matter what kind of interaction they choose, whether it's international or supranational, they still will be guided by fundamental principles of international law, including the principle of sovereign equality. It's a fundamental principle of international law, and it will always be in the foundation of any instance of powers delegation, including the situation where the powers are delegated on the supranational level. Thank you. Thank you, Tatiana. We have another speaker now who participates in this group. He is head of research programs of the Center of International and Comparative Law Studies, Mr. Usoskin. Thank you. Many colleagues have agreed that there is no major conflict between sovereignty and supranationalism if supranationalism is exercised appropriately based on the state's consent. But there is something else I'd like to discuss, a possible conflict between sovereignty and supranationalism, different levels of international regulation. In addition to integration associations and international treaties, there are other different international treaties which the states enter into. And in case of integration associations, because integration is especially deep, and because there is a uniquely broad range of issues regulated by such an association, there's more potential for possible conflicts and clashes. Let me illustrate that using two different examples. Let me first begin with the European Union. The European Union, as you all know very well, regulates as a union issues as granting subsidies. At the same time, a member state of the European Union must write an agreement or treaty on investment protection, granting guarantees to foreign investors. A recent problem, which many of you are familiar with, is Mikula versus Romania case. In that case, original subsidies and privileges which were granted to a foreign investor were found as conflicting with the European law on subsidies, and Romania had to revoke the subsidies. After the revocation, the investor came to the arbitration tribunal, which found that the investor's rights had been violated, and then Romania had to pay the award. The European Commission decided that the compensation would be another form of subsidy to Mr. Mikuli and forbade Romania from paying the compensation. So Romania is now in a unique position, in a unique situation. They have a conflict with the commitments under the European Commission, which said no to the compensation, and conflict with the investment protection agreement signed in Sweden under the Washington Convention, and there is no mechanism of dealing with this conflict. The state is in a unique situation where it has to violate one of the two commitments. That mechanism in the European Union was designed for treaties signed with third countries. Article 315 says that the treaty with a third country will have a priority. That's why the Mikula case this has less significance than people say. But this example still illustrates the significance of appropriate assessment, situation assessment, every time you delegate powers to supranational delegation, because it may create a threat, a risk for the state which will be enabled to respect other commitments. In an instance, there is a conflict. Looking at the European Eurasian Union now, transferring the same situation to that union, I can say that its jurisdiction is being expanded gradually, and the customs regulation under Eurozec could theoretically create the conflicts but never created them, while the expansion of integration to include individual regulations, including customs regulations, creates a lot of potential for future conflicts, and I do not see ways to resolve the conflicts. As a practitioner, you may ask yourself a question. If an investor's rights are limited by terms of reference, and those terms of reference or rules are found as violating the state's rights and responsibilities related to the investment protection, what can be done? And if there are no existing mechanisms to resolve it, who will be responsible for that? And if there is a mechanism for the transfer of responsibility from one body to another, two possible solutions may be designed. You may either create this mechanism in advance or resolve problems as they occur. The practical experience of the recent years shows that it's easier to resolve such issues before they arise. Even though the Eurasian Economic Union shows that because its member states have common interests, the Union may change the existing regulation in response to new challenges, like was the case with WTO sanctions. Because the Russian Federation is a WTO member and may impose sanctions where its rights are violated, but actually, practically, it is difficult to do, because at that time Russia was a part of the customs union, the Eurasian Economic Community, Eurozec. But EU found a solution of that problem. Maybe search for solutions of investment-related conflicts is in the same area. That will be the next stage of development in situations where a lot of powers have been delegated to the supranational level.
Thank you. Thank you, Sergey. Dear colleagues, we seem to have had all the presenters, but we have Deputy Minister for Justice, the Russian Federation, Maxim Travnikov. He was very instrumental to have this particular roundtable. So we could allow Maxim to say a few words, to become our panelist. But of course, we need to adhere to the sovereign equality principle. Thank you very much for this initiative to have this roundtable today. I think the discussion has been very interesting. I've been making exhaustive notes. I don't want to comment everything that I might want to comment, but there are a few issues I would want to make clear. In particular, I would like us to talk about the facts about Commission not having the right to go to court. I don't think this was done by accident. Myself, like many of those present in this room who were involved in the drafting of various functions, including that of the Commission, as a result, we decided against allowing them to go to court because we thought about the nature of this commission. This commission has a dual nature, and we mentioned that it is a supranational body with certain competence of supranational nature, but it also includes official members of the member governments. For the commission to go to court, the board of the commission should allow for that, and this is a strange situation whereby the vice premiers who make up the commission would have to rely on the consensus to go to court against their own governments or one of the governments. So when this model was presented to the boards of the commission, and we were in constant negotiations with them, one of the vice premiers said, "Are we suing ourselves as a result?" I'm sure he said we can do that in a different forum at the intergovernmental level. So hence, as a result, the Commission cannot go to court. But the right to seek interpretation from court or explanation from court is still with the Commission. And it is an important right. This is an important right, an important method for preempting disputes out of court through the interpretation, judicial interpretation. There were no precedents, but given such precedents, I'm sure our colleagues in courts will find it much easier to work. And again, this dual nature of the Commission can serve a very good example to which Mr. Suarez referred, which he talked about the multiplicity of sovereignty, and this sovereignty is used for cumulative effects. The interaction of governments within the Commission without giving up their sovereignty could pass supranational decisions. I don't need to comment about the link with national administrations, but I'm quite sure we need to to ensure there is a link between the Eurasian Economic Union courts and the national courts. There will be need, I'm sure, for more harmony in decision making, and of course we need to involve the Constitutional Court as well. Thank you. Thank you, Maxime. It's an interesting explanation, and I'm sure we still have a bit of time to discuss this. The issue of dual nature may be both positive as well as risky. And some of the risks have been mentioned, some may not have been mentioned. But this is something that we've got in hand, and we need to do something with what we've got. Well, we have just a bit of time for two more points for discussion. We wanted to have this as a roundtable discussion. I want to use 5 to 7 minutes for questions and answers. Please, Mr. Bachin from St. Petersburg University. Thank you very much. I think thanks are due to the organizers of this roundtable. Before we have this one, we had a Mercosur roundtable in the same room, and it looks for integration. We seem to have the same concerns. We may always want to refer to the experience of the European Union. They have rich experience, they have a long history, but not all of their models are perfect. So this is just an idea that I have, that we probably need to look elsewhere for integration models. I have a suggestion why we just forget about the term of supranationality or supranationalism. If you take the Eurasian Treaty, you would see they are talking about intergovernmental level. If you look at their bodies, they are all intergovernmental, not supragovernmental, supranational. There's always this concern in any integration association about bureaucracies. Bureaucrats are there to implement decisions. Which kind of decisions? Intergovernmental decisions. So this is something to think about. But I have a question to Tatiana as the key expert on courts. In paragraph 47 of the statutes, it says that the court gives construction, and then also it says that governments may resolve issues otherwise. We were talking here about things from the point of view of governmental interests, but what about businesses? The legal system in the Eurasian Union should be straightforward and clear. Again, we're saying this is the breathing law, it will be changing, it will be evolving. But let's look at that from the point of view of the business. If we keep promising them that things will be improving, things will be changing, their business and the purpose for which this integration is being created, this integration will never work. So going back again to courts interpreting this or other rule, what will be the status of this ruling if governments decide to move elsewhere or to do something else, otherwise? Very good question. We have two authors here who contributed to the drafting. I don't think this sentence have any implication. Interpretation, as you know, is very strict in its form. You should have the body that will be allowed to interpret. So which agency in the government will be interpreting the international treaty in the Eurasian Union, which says, basically, this treaty, that the only interpreting body should be the court of the Eurasian Union. The Constitutional Court actually was trying to maintain that they will be interpreting as far as the human rights are concerned. But Constitutional Courts of Germany, France are saying the same for 30 years. And only 1 year ago, they finally appreciated they can't do it, all of them. They should either have one body or they forget about the unification, about the harmony. This is not an easy road. I'm not sure I will live to see the results, but you were right in posing this question. Everything that we do should be done within thinking about the purpose. The purpose is to improve the lives of our people, creating a space where people will be living better. You may be not in agreement with me, but only judges can think properly about that. But of course, they need to forget about their nationality, and it's difficult for us because we used to work and breathe like bureaucrats, but we want to do it otherwise, to do it differently. Bureaucrats will try to do it differently. They will try to tug and try to get more and more of competence. Only court could say you should think about human rights, you should think about the people, so you should do it like that. It is not an easy way. It is not an easy road, but this is something we will probably achieve. Probably not in my lifetime, but sometime. We are moving our way. We may be making mistakes, but we will come there ultimately. But I don't agree with you, Sergei. If we continue shouting and crying that the governments don't want to cede their powers, there will be no integration. We have been crying havoc all the time. If we continue doing that, instead of accepting that the contemporary international law has created a new objective rule because of the internet and telecommunications, there are no borders anymore. We could continue shouting that things should be as before, but in fact it is not, because we need to respond to the new telecommunications. We need to transfer sovereign jurisdiction. The crux of the matter is how much of it we should delegate. Probably not like Europeans, because now they think that they have ceded too much. I'm sure we will be able to find, but we should stop saying it is intergovernmental integration only. We start with that, but it's only the starting point. We may be only starting to do that, and we have to learn. Look at the European Union. They were successful the very first 10 years. Then there were 10 years of failures, and then again 10 years of successes. And now we have again back to failures. We may have the same seesaw in our union, but if we remember about the purpose, we need to make the space of our countries a place where people have a better welfare. We could achieve something. Could we do that? Could we succeed? It depends on our generation. It depends on our academics as well. They should forget about talking about the governmental sovereignty. Sovereignty is not governmental. It belongs to the people. You may talk to Sergei, I'm sure, but we don't have that much time. Could I say something about the role of the judiciary and its interpretation of the jurisdiction of the governments. I can't refer specifically to an author, but somebody said about the competence of the European courts. He said that the court as a caterpillar keeps biting on the sovereignty of the states in favor of the jurisdiction of the Union. This is not the nature of the court. This is the will of the governments. They decide what should be delegated to the supranational authority. If there is no will, if the governments do not agree, they cannot negotiate, then it is up to the courts. But in the Eurasian integration, the governments are capable of agreeing on the majority of issues. Sergei, in his question, has started a storm, and we see some comments coming from Mr. Miguel de Serpa Soares. She wanted to comment too. And Mr. Soares used to work in some of the bodies of the European Union, so his opinion is important.
Thank you so much, Chair. I wanted to comment briefly on the role of the judiciary in integration, because I think that role is fundamental, and without judges and courts, there is no integration to start with. And I wanted to look at the example of the European Union, where two of the most essential principles for the integration, the principle of primacy of European law over national law and the principle of autonomy, are not even mentioned in the original treaties and were designed by the judges in Luxembourg. And yet the primacy of European law over national law is an existential condition of integration. Without that, it would be very difficult to imagine the common ground between states. So the Union as it stands is, if you want to use a term from political science, is a confederation of states, but with some federal elements. And the main federal element is the judiciary. The fact that the decisions by the court in Luxembourg take precedence over the decisions by national courts. And I was following very attentively our colleague from the advisor to the Constitutional Court, because much of this debate actually relates also to the constitutional law of states, how to accept this dialogue with foreign legal orders. And in the case of the Union, is so extensive, the integration, and here I disagree with our colleague from Belarus, who just mentioned that trade was the only success. No, I mean, you have many common policies from environment, internal market, even education, and there is a common foreign policy, which is still more intergovernmental on its nature, but it still exists. And without the role of the judiciary in all these, it would be very difficult to make progresses.
Thank you. Do you want to make a comment? I would like to give the floor to Ms. Abova.
She is a scholar and a professor. Yes, I'll be brief, of course. You know, this issue, in general terms, can be resolved not just on the international level. It may be resolved within the state, and everywhere it's the same. The judicial power is above all. As for negotiations, of course, you want to come to court only after negotiations prove to be useless, and the same principles must exist in every state. They must be respected in relationship between different companies. Negotiations are the main tool, and in every democratic state there should be a choice between the court and negotiations, and there must be a chance to resolve the issue amicably. If that doesn't work, the court is the only body which can issue a judgment which will be enforced. Yes, more questions? One more question and then a closing discussion, because we don't have a lot of time left. Speaking about the comparison between sovereignty and subnationalism, you know what surprised me? For some reason, none of you mentioned a document. A document which was initiated by the Constitutional Court of Russia. It's the decree which they issued after one of the courts approached them. So the decree, the order is, the ruling is this. As for the protection of human rights and freedoms, the Constitutional Court shall reserve the right to analyze the decisions made by the Eurasian Economic Commission and see whether they conflict with human rights. My question is simple. Is the Constitutional Court believes that they can analyze such issues and see whether they conflict with people's rights and freedoms, and they include every aspect of economic life. So does it mean that the Constitutional Court, if they find that a decision of the Eurasian Court conflicts with human rights, rightly or wrongly, does it mean that they will reverse that decision, that the decision will no longer be binding in Russia? And doesn't it mean that other constitutional courts or bodies will be analyzing and reviewing the same decisions issued by the Eurasian Court and make different decisions for the same cases and ignore the decision of the Eurasian Court? Well, and I think that national and international courts should at least read each other's judgments before they quote them in their rulings. In that judgment, it had to do with defining a 5-year-long period for customs situations. But the appellate chamber of the same court, in its ruling, reversed the decision made by the trial court. So the Constitutional Court responded for nothing. It's one of the two things. Either they did not read the ruling by higher court, or they just took what they needed to pass the ruling. Yeah, I understand. You ask more than one question. Yeah, I know, but you know, in that ruling, they make reference to the decision of the Eurasian Court, and they issue recommendations to lower courts of Russia. But under the Constitution, lower courts of Russia can apply laws in the same way as higher courts, and they are obliged to protect people's rights and freedoms. Does it mean that lower courts are entitled to reverse the decision of the Eurasian Court as well? They may take their judgment, analyze it, review it, and say, no, we disagree. So how do you think then will this single system operate? And by the way, the single uniform system is a prerogative of the Eurasian Court, not national courts. Very briefly, Tatiana mentioned that. She mentioned that decision of the Constitutional Court, and a good mechanism exists. Very briefly, I may tell you that those fears are overestimated, overstated. Can you hear me now? Let me repeat that those fears are overstated grossly, because the Constitutional Court is very careful when they review international treaties. The Constitutional Court has loads of other rulings where the court says that it cannot interpret provisions of an international treaty. That is number one. And it's a very stable approach, and this approach is closely linked to their jurisdiction. Also, the Constitutional Court reviews complaints in the context of a specific case. In that sense, you can't generalize. And in that specific case, when the Constitutional Court issued the ruling, I believe that the Constitutional Court had reasons to issue a ruling in that instance, but it does not mean that they will do the same in all other instances. It's not a universal principle. Thank you. If I may, I'd like to add some. I cannot speak on behalf of the Constitutional Court, but I can speak on behalf of Russian academic community. Yes, any attempt to shake the constitutional order should get a lot of attention. But Tatiana is right. A lot of other states have been here, and initially the integration project left human rights behind the scope of their jurisdiction. But let me tell you, we have a mechanism. I'm not going to describe it in a lot of detail. Let's have another question and move over to the conclusion. Ellen Jua, Minister of Justice from South Ossetia. First of all, I'd like to thank Maxim for the idea to have a roundtable discussion and facilitators for a splendid discussion and very useful knowledge. For South Ossetia, it's a very interesting subject because in March this year, Russia and South Ossetia signed an agreement, a treaty on cooperation and integration. It's a huge, large-scale treaty. Integration processes are inevitable, that is what I believe, and they help us solve issues together, the issues which countries cannot solve on their own. To say that sovereignty is in the way of such processes would be a mistake. If a treaty complies with the Constitution and domestic legislation and with all the necessary procedures, and the nation, the state, voluntarily delegates its powers to a supranational body, I don't see any conflict. But I agree it's a sensitive one, it's a sensitive issue, and I support my Belarusian colleague. The treaty must be very clear and very detailed, and it must give a very clear description of the powers delegated to the supranational level, joint jurisdictions, joint powers, and the powers which are not within the jurisdiction of supranational body. If we have just detailed definition, we won't have problems. Thank you. Now, that's the end for the questions, but we have 3 more people who'd like to make comments. I give each of you 2 or 3 minutes. And now I'd like to give the floor to Pavel Laptev, who is head of department in Anatoly, Alexei, Maxim. Thank you so very much for this exciting discussion. It was a lot of fun, but there is something I disagree with. We have discussed Eurozec very well, but we have lots of other problems, and there is a problem which has been mentioned indirectly. It's the comparison of the Constitution and the integration processes. The Constitution, for the first time since 1993, says that it is illegal. So Part 4 of Article 15 exists beyond the limits of the Constitution, and the Constitutional Court has expressed its opinion about that. So you see, the problem is bigger. At this meeting shows that sometimes it is a good idea to stop and think. I really liked the presentation by Vigan. 30 years ago, my colleagues from the prosecutor's office discussed perestroika in the republics, and there was a prosecutor from Armenia. He said, you know what, the prosecutor's office of Armenia wants to deem the perestroika as complete, as finished, because people were afraid the prosecutor's office system would just break apart, and they wanted to put an end to it. Another thing, the term of bigger Europe has been used a couple of times. What is it? Is Belarus a part of bigger Europe? What about South Ossetia? What about Armenia, Azerbaijan, and Georgia? Are they part of bigger Europe? Not quite. South Ossetia is not a member of the Council of Europe. What about Kazakhstan? What kind of Asia? How is Kazakhstan different than Turkey? It is not. Both of them are located partly in Europe. You have to be very careful about that. What if the UK chooses to leave the EU? What kind of bigger Europe will it be? Not very big. Not very big. I'm quite happy with our discussion and analysis of Eurozec, but we must introduce some more clarity about Europe. We must be prepared for any scenario. Any scenario. Even what will happen if we don't have the European Union, European Court? We should think about it in the context of BRICS. I'd like to give the floor. Let me give the floor for brief comments to Mikhail Yofa, head of Legal Assistance Center, which is called Moscow and Russians. Thank you very, very much for a chance to speak. My thanks go to the organizers and facilitators. I realize we've pressed for time, but I'd like to speak about illegality of prosecution of citizens of former Soviet Union for what they did between 1941 and 45, for the crimes which qualify as genocide and war crimes, and we must develop a mechanism to prevent it in the future. The state sovereignty is in conflict with international rules and principles established by the international community before that. Ex-Soviet countries create now precedents establishing guilt of people who lived in the Soviet Union and who are now members of ex-Soviet countries, and now the guilt of the aggressor is reviewed now after the political regimes in those countries changed, and people who took leading positions in the government or who were just public officials are deemed a priori as representatives of an occupant state, and they lose presumption of innocence privileges. They cannot defend themselves in criminal trials because the guilt of the state, which existed prior to 1991, is proved on the basis of international documents, and the specific guilt of a person who is on trial is proven as automatically. But the defendant is incriminated with something that they did in the country which no longer exists. And here the court has to act retroactively because you cannot convict them otherwise. That conflicts with the Declaration of Human Rights and European Convention, Article 7, but still they occur pretty frequently in the world today, and that creates universal jurisdiction of national trials. It's a kind of extraterritorial jurisdiction which gives the state jurisdiction to prosecute people irrespective of the place of crime or citizenship of the defendant. The universal jurisdiction is a function of the nature of the crime, which are prosecuted universally by the international community. I can tell you, I can remember the Konev case. Konev was a guerrilla fighter. He was found a war criminal. He was a man who executed people based on the decision made by the guerrilla tribunal. And he was found guilty, he was convicted. The Convention of 49 was used, but it was used in 44, which was not acceptable. And another case is Lithuania, where more than 113 Russian citizens were tried for what happened in '93. They were tried for what is defined as war crimes, and the European Court declined the complaint of the Russian citizens. Therefore, the use of sovereignty by the states against the interests of justice is quite unacceptable. Mechanisms have to be created to deal with such instances in the future. Miguel Suarez said quite rightly that sovereignty must be defined and it must have its legal limits. Otherwise, we'll deal with a lot of frivolous judgments. Thank you. Thank you very much, Leonid. I think that the subject deserves more attention. The situations that we deal with in the republics which are infested with neo-Nazism, those who currently make heroes out of Nazi criminals go deep in history and has a deep historic context. It's something that we have to deal with separately. There is a minute and a half left. Instead of drawing up conclusions, I'd like to ask the speakers if they want to say one or two words, make one or two comments. I realize that the discussion will go on. No, you're not going to make any final comment. Then, co-facilitator, you have the floor. Thank you very, very much. Thank you for the words of gratitude. I hope that next year we'll carry on with our discussion. A couple of things to say. Very often when we speak about supranationalism, arguments for or against it are the arguments which are used in favor or against classical international organizations. But international cooperation does not necessarily mean supranational cooperation, and we are yet to understand what we mean when we say supranationalism. As I compare the processes in Eurasian economic space and in European Union, they're very different. In EU, under EU treaty, all decisions, or the vast majority of decisions, are made as a result of consensus, which is a serious driving force, and Each state has the right of veto. They can veto any decision, and this consensus principle does not automatically mean supranationalism. If we lawyers deal with a document and speak about supranationalism, what may be supranational is the forex body which is yet to be built, unlike the European system, where they have a different system of voting, weighted system of voting, and it's a different story. We speak about sovereign equality of states, about the principle incorporated in the UN Charter, but the principle of sovereignty respect remains. It's an excellent example showing how after 1948 the system of international relations changed. But we cannot describe one principle unless we speak about another related principle of international law, which will help us better understand sovereignty and supranational processes. Thank you. Thank you, Alexei. Colleagues, I'm not going to take too much of your time. The level of discussion was very high, very professional. There's still a lot of questions or issues which we are physically unable to discuss within just 2 hours that we were given.
We have heard from different representatives of the Eurasian Commission, of the national governments, and the Eurasian Commission for us is the highest supranational body, together with the court of the Eurasian Union. It is supranational, but probably they need to acquire more wings to fly, as it were. For integration, I think we have been implementing this concept of Eurasian integration, or rather integration with the Eurasian specific, and you've heard about the specific features a lot. There could be different interpretations, but we clearly have the basis for advancement, and I agree with Tatiana. These things are done not for the benefit of international bureaucrats, but in the interests of all member countries, for their peoples, who might see their well-being improved as a result. From this point of view, integration is the right way to move, and we need to be supportive of it. I think there is another issue of conflicts between constitutional norms and treaty norms. This is a possibility, and this is something that the court should look into. There could be amendments to the underlying treaties, but there could be also conflicts with other other rules of domestic law. For example, we have this recent practice whereby the proposed law is being analyzed. We are asked sometimes to vet all legislative acts that have to do in any way with Eurasian treaties. They will be vetted by us. There were a number of occasions in the recent months where some of these acts were in conflict with the underlying treaty, and we were supported by the Ministry of Economic Development, who maintained that in the case of blatant conflicts, the Eurasian law will have primacy. But of course, there's always a recourse to court. And again, if the case goes to court, it's another opportunity for the governments to discuss that. Thank you all very much for coming here. Our colleagues from the Eurasian Court, the Eurasian Commission, our colleagues from the Ministry of Justice, our partners from Belarus, Armenia, all of you who came here to contribute to this common cause, and we'll continue to think about the jurisdiction, about the applicable law, and look for the best working solutions for the benefit of our people. Thank you very much for all of you who came here. We do appreciate a lot of questions for the academics, and we will be going back to the same agenda next time. Thank you very much.